Today I'm at the Cross Keys in Nottingham City Centre, and I'm here today to talk about listed buildings in the context of alterations that are undertaken at a licensed premise. Lots of licensed premises these days in particular are listed, partly because a number of pubs and restaurants in particular are of some antiquity, and usually a building that's more than a certain age tends to automatically be listed as a matter of course for perfectly understandable reasons. I do have to say, however, when I was at Eldridge Probe, I did have a pub that I think was built in the 1690s, in fact, and when we started to undertake some fairly extensive refurbishment works, which included actually extending the pub, it was discovered it wasn't in fact listed, although rest assured it got listed pretty damn quick following that. There's three classifications of listing. There is grade 2, which the Cross Keys is a grade 2 listed building, and that's a building of special interest. You then have grade 2 star, which perhaps as the title suggests is special interest plus. In actual fact, one of my old premises, Cast, which was in fact only built in 1963, was grade 2 star listed, considered to be architecturally of significant value. And then you have grade 1, which are places that are of exceptional, or buildings that are exceptional special interest. In terms of Nottingham, Wollerton Hall, for example, is a grade 1 listed building. Whether a building is listed is ultimately down to the Secretary of State, and I would expect most people who own licensed premises or even have leases on them are aware of the listed building status. Obviously, at any point that they take those premises on, that's something that would ordinarily be information that would be made available to them. Why is it important that licensed premises take their obligations in relation to listed buildings into consideration? Well, firstly, without trying to pontificate too much, clearly if you have a building that has cultural and historical value, it has a value to the community that extends simply beyond its permitted use. And my view is anybody who owns a building or has a lease to such a building has a responsibility as a caretaker for that building. And so that's one reason. Second reason is that having a building that is listed, it usually means it's considered to be attractive and interesting, and so it's actually, in actual fact, an asset in many ways to have a listed building. So it's important that that is nurtured and cherished as much as possible. But in addition to that, on the flip side, in enforcement terms, then a listed building, people that fail to comply with their obligations or undertake works that they shouldn't, then the enforcement of such failings or actions, in those circumstances, the penalties can be significant. First of all, listed building officers tend to move much more quickly, for example, than planning officers. The fines that are handed out by the courts are usually more significant. In actual fact, within the sentencing powers, the court is permitted to take into account any benefit that an individual has derived from their failure to act or the way that they've acted in relation to a listed building. And the speed at which matters move within listed building circles, in my experience, is much more quickly than it is within planning enforcement, for example. So for all those reasons, it's hugely important to ensure that you are complying with your obligations in relation to a listed building. And in saying that, it's important to remember that even if you're conducting small alterations to the inside of the premises, sometimes even ones that are cosmetic, that is something that will probably engage the listed building process. So my advice, if a building is listed, is to engage at the earliest available opportunity with the appropriate authorities. I would just lastly add that in terms of a licensing authority, whether a building is listed or not is not a consideration for them when dealing with any application. But it's also important to remember, if you are undertaking alterations to the premises, if it's going to engage listed buildings, then in all likelihood, unless it's simply decorative, then an application may very well be due for variation under the Licensing Act, be that a full or minor variation. So please bear that in mind as well when commencing the process of refurbishing or altering your pub, bar or restaurant in any way.